Hi, this is Professor Walls. Coming to you on week 2, and there's a few things I want to clarify that I think if you looked at the scenarios or when you looked at the lectures might have been confusing. And that is two concepts. One being incorporation. Now this is it is difficult to understand. Incorporation really means the Bill of Rights. Instead of just restricting the national government from violating them, which is what was originally put in the Constitution or the original intent of the framers, in incorporation it means that now the states can't violate the Bill of Rights or the civil liberties of American citizens. So I just confused it. One of the ways that I help students when I'm in a face-to-face class is I have them look at the First Amendment. The First Amendment there's 5 rights. I'm sure you've read this already, or you will read this. And of the 5 rights, one of those is freedom of religion. There are 2 specific terms used there, and one is the Establishment Clause, and the other is the Free Exercise Clause. So those 2 clauses in the First Amendment are what we call our religious rights. When those were put in the Constitution and ratified as the Constitution was amended in 1791, it only restricted the national government. So throughout the United States, you saw violations of religious freedom. You saw people who were Catholics not being able to practice their religion. You saw people being barred from jobs who were Jewish or weren't the dominant religion within a state. Many states had laws that if you were Jewish or Catholic in the South, you could even hold office or you couldn't have certain jobs. So there was a lot of violation of the religious freedom by the states, even though the Constitution had restricted Congress. If you look at the First Amendment, it says, Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. So the First Amendment then really only limited the national government. When the 14th Amendment started being used by the Supreme Court and applied to specific parts of the Bill of Rights, that means the Bill of Rights were incorporated. It means states could no longer violate them. One thing I want to caution you is when you look at the film, you may be under the false impression that once the 14th Amendment was passed in 1868 and said no state shall violate the equal protection under the law or the due process clause, that immediately these Bill of Rights were incorporated, and that's not what happened. And that's why I always start my lecture on civil liberties and civil rights with this real simple phrase: the Constitution means what the Supreme Court says that it means. Yeah, that's right. It sounds really ridiculous, but the Constitution means what the Supreme Court says that it means. And when you have a majority, 5 out of the 9 court members, justices, who believe that the Constitution provides for equality over, let's say, economic liberty, then you will have a Constitution that stands for equality. But when you have a majority of the court that, let's say, supports the right of liberty of property over equality, you're going to have a Constitution that does not protect the civil rights of various groups, citizens of the United States. So that's why it's very important to understand when we talk about incorporation. Just because there was the 14th Amendment put into the Constitution, it wasn't really even looked at until 1925. 1925 is when speech of all was first incorporated. It would be the first. The religious clauses that I talked about earlier, and the Establishment Clause and the Free Exercise, weren't incorporated until the 1940s. In fact, the Free Exercise Clause was incorporated in 1943 in the middle of World War II, when it said that states could no longer force Jehovah's Witnesses to pledge allegiance to the flag. So that would be a case that not just the First Amendment was incorporated, not just freedom of religion was incorporated, but a specific part of it, and that was the Free Exercise Clause. The Establishment Clause wouldn't be incorporated until the Everson case in 1947. So when we look at incorporation, it's very important to note that it's the civil liberties, or in America, civil liberties are really narrow to the rights of the individual, which are listed in the Bill of Rights. Civil liberties weren't incorporated. They didn't start until the 1920s, and it wasn't really completed until the middle of the 1960s. Most of the Bill of Rights amendments, the 4th, the 5th, the 6th, the 7th, and the 8th, what's called the rights of the accused, are not going to be incorporated into the late 1950s and until the 1960s. You'll read about those in the chapter on civil liberties. But one other caveat about incorporation: there is an error in the lecture, and it's simply because it's old. And that is, the Second Amendment has been incorporated. It was incorporated in 2010. And the best way to explain that is, you had a Supreme Court case where they changed the ruling of how the court interpreted the Second Amendment. The Second Amendment says a well-regulated militia being necessary for the protection of the state, the right of the people to keep and bear arms shall not be infringed. Until 2010, the consensus was that that was a state right, that the Second and 10th Amendment were state rights, not individual rights, whereas the 1st, the 4th, 5th, 6th, 7th, 8th, and 9th have always been identified by the Supreme Court as individual rights or civil liberties. The Second Amendment was not considered an individual right. In 2008, the court ruled on a D.C. case that yes, the right to bear arms was an individual right, not a state right, but it wasn't incorporated until a 2010 case. All of this is listed in my lecture notes that I have posted. Also, I have posted lecture notes on civil liberties and civil rights with some links you might want to look at. One other thing I want to make sure you note also is that the videos try to make a difference between civil liberties and civil rights, but I'm not sure it's very clear. Typically, political scientists think of civil liberties as right of individuals. And in the United States, those civil liberties are those which are written in the Bill of Rights. Civil rights are rights that individuals are being denied because of membership in a group, and they are protected under the 14th Amendment Equal Protection Clause. So the 14th Amendment is very, very important in our story. In fact, it's the most cited amendment of all amendments by the Supreme Court. You have the Due Process Clause and you have the Equal Protection Clause. They're two different things. They also were not used by the Supreme Court until the last 100 years. So it's real important to understand that the Constitution is more than just words. Its meaning changes, not because it's amended, but because the composition of the court changes. You have a liberal court, then you have a court that's more likely to support equality issues. When you have a conservative court, you have a court that's more likely to support liberty of property issues. And so it becomes very, very important that you look at this in a way that civil liberties, individual civil rights, or groups. Civil liberties are the Bill of Rights. Civil rights have to do with the 14th Amendment Equal Protection. I hope that clarifies it. If you have any questions, go back and look at the lecture notes that I posted. They don't really follow the text that you have, but I think it can give you some more insights if you're confused, and I have some links there that I think will help you understand, not necessarily your assignment, but some more things that you might be interested in. The assignments as designed are really designed for people who are interested in criminal justice, and so that's why the emphasis is on the rights of the accused, which is a very important part of American government. And also the course is designed for individuals who are already in the workforce or looking for a business degree, and so they're talking about harassment in the workforce. But if you look at your chapter and you look at a lot of the work that's done on civil liberties, I think you'll find a lot of very interesting topics that we don't have a chance to discuss in this class. You can find some links that can help you learn more about that. So let me know if you have any questions. This is an incredibly exciting week. I don't know what else to say other than it's amazing. It's kind of overwhelming that they put both of these topics in a 1-week lecture. When I have a face-to-face class at other institutions, traditionally I have spent 6 weeks on just this topic and not one. So you're asked to do a whole lot, and I don't expect you to become experts, but this week's lessons on civil liberties and civil rights are so important because so many Americans don't understand these basic distinctions between civil liberties and civil rights. They don't understand about the court's role in interpretation, and I just wanted to try to help you. If you have any other problems or conflicts or confusion, please let me know. I'll be glad to give another video or pass some notes. Have a good week and contact me if you have any problems. Bye.